To me, it's magic that I have a phone that does everything, pretty much, a supercomputer in my pocket.
All right. So this is just a live stream.
Oh, look at that. So Robert, I'm gonna put yours right after my Times Square picture here. You can tell this is originally your deck because from where I got these pictures, these two here. Very good.
You can do that, and you disconnect mine, because I'm gonna leave the USB here.
Yeah, that was my thinking.
All right.
We can't save.
Oh, that would have been my choice too. Good choice.
Which one?
Guac and chips.
Oh, yeah.
Yeah.
It was long. Actually, it's on.
Save as, okay.
I have no idea what that is. Sorry.
My name is Eloise. I'm visiting. I'm doing a story on FedSoc. I just the head of FedSoc said this event was open to the public.
Okay.
Yeah, I was wondering.
But I didn't say
All right,
it.
all right. If not, it's totally okay.
He's another speaker, so it's okay with me. Just make sure he's good with it.
Are you okay if I record?
Yeah.
Okay.
I think we're live streaming on YouTube.
Okay. Thank you so much.
How's it going?
Good.
How are you? Are you doing one?
I work for health. Yeah, I work for
I'm sure you are. Okay. Awesome. Welcome.
Thank you.
Well, like I said, dial back myself.
I mean, at least there's a warning, right? So that's nice.
Here, Robert, why don't I?
Let me put, oh, sorry. So are each of you going to be doing a lecture and then a lecture, or are you going to be doing a discussion?
I think kind of a lecture and a lecture will.
Okay, so you'd like to push it up?
Sure,
Okay.
sure. Or we, I think somebody, maybe it was you, said it would be like a panel kind of, so I'll talk about some and then we'll talk about other aspects.
Okay, maybe I'll leave these chairs up here so when
There any particular angle?
together,
Okay.
maybe answer some questions, and then, but I'll leave that for the end.
Okay.
But we don't have people yet.
Robert, what's your middle initial? Do you use a middle initial?
Yeah.
Your associate assistant? What's your?
Assistant, yeah. Low on the totem pole.
And what's the name, George? And
George Mason University, Hampton School of Law School.
Oh, yeah.
Or whoever you want to put it at.
I spell all that right, I have no idea.
That's all.
All right, look at that. Putting technology to work here, that's what we're doing.
And we'll just start, and, you know, we usually give them about 5-10 minutes to just kind of come in. You get to
Robert, is this one yours?
No, I took mine.
Oh, you took it, all right, good.
How are you feeling about tomorrow's exam? Well, I'm trying to figure out what it is, so that's like, yeah, I think that's cool.
Yeah, I don't know where Louise is.
Where's Luis? Yeah, nowhere.
I don't know where Gary is.
I'm gonna say hello to everybody on the stream. Professors, welcome.
Thank you very much.
Haven't had a chance to meet with John Montana. Sorry.
Robert Lytle.
Welcome. We look forward to it.
How big's the chapter?
In terms of immediate members,
Yeah.
10 to 12.
Is that all you
These
have?
events?
In terms of turnout, we have a few
You only have 10 to 12 members.
active members. Yeah, yeah, it's pretty slimming.
Is that indicative of the political leanings of the student
Absolutely,
body?
a fun way compared to Mason, where you are. Yes, that's,
Yeah, everybody's fighting it out.
and Mason, it's a rite of passage to go. I don't know who's who. Here, it's
He's on.
I'm just a 6 foot pole.
No.
Yeah.
Oh.
So we
I mean, maybe
Are
like, my campus is
actually
working group,
Where do you think, Robert?
so
you're.
you get
you're all here.
but I don't know, if other people.
Yeah, you may as well.
You know?
I realized that I'm more by the materials.
Yeah.
Because I don't have that perspective. We were pretty balanced student body politically.
Yeah.
We're like actually balanced compared to America as a whole.
We did a
Yeah,
little bit.
I don't have the perspective that's
Like,
overwhelmingly
like
lopsided politically.
We had some for like, switch over like a couple times, and like, I think I helped you remember it, but like also like, it won't be did in like 2.5 hours, I could try doing it. No, it's not good.
What I think I need.
Oh, no.
It's so comfy.
Oh, no.
I don't know. Yeah, right.
No, I'm not.
It's very cozy.
LinkedIn almost.
I probably pull like.
Okay, I already. Sorry, I was late.
It is kind of.
It is a point, it's a shoulder.
In the fashion, it's called the shop.
So,
Oh, you know what I meant to do is
Maybe in the real world, it's blanket.
delete it from the desktop.
It's very cozy, very cozy. It's just, it's been kind of wrapping up in it.
I'm gonna try to move the clock.
So they were just saying about, bringing the 90s spot.
I'm not a big fan.
I like roads a lot. I love a road.
I just like
But I was
being
doing
warm.
talks during COVID.
So,
What I noticed is everybody
What area?
the same way.
What
Always
area?
1 L or 2 L?
One out.
Sweet.
Better than the yell.
My first semester. I'm gonna take you one. I work, and this is my first number side. I want to get more involved, but I know that you guys can have like meetings, right? It's just these.
Yeah.
I
Motto like debate, discuss.
How do you find out about
And it's just like triggering people to debate things.
You want to give you more.
Try to find people on both sides of the aisle
Yeah.
that, disagree. And so, it just kind of depends. And then people can come and they listen and they decide what they want to, what they.
You don't visit people on the other side too?
Yeah.
Yeah.
Maybe that too.
Is there man?
I think so,
Yeah, yeah, so, Louise is the one who you can do the policies. And he sends out, reminders just for all of our desks, so, yeah. Yeah.
Wait, did you see the email where it was like applying for like the house one fair thing?
Yeah.
Was that, so as a one-hour camera do externship?
Thank you so much.
Yeah, you can, yeah, you
Yeah.
can definitely do it.
Are you guys?
Maybe they give you.
I sent it in.
Are you
I sent it in.
Oh, you mean for the spring? I'm sorry, I thought you meant for the summer. No, for the spring, I don't.
Usually it's a mix of.
And I just don't think that.
Is it like a rule that you can carry now, or is it like?
Well, I don't think you could get academic credit for it because I don't think they would let you.
Oh, yeah, actually, I feel like the sheriff's office, if they give you credit for it, or they won't give you credit for it.
Oh,
One of my work colleagues gave me one, apparently it's the coat of arms, because he had served in like some.
I was like, that's like.
That's a big issue.
Yeah.
I think we're gonna.
Yeah, well, I mean, like,
Yeah, but road,
even
like,
if you're not gonna go for it.
Yeah.
Hours.
Yeah.
That's just hard.
Well, I feel like I just have a bad outlook on experience when someone's like, oh, it's so hard. I'm like, oh, that's not that. Like, obviously, like, it's like way more work than what I'm
I
used to.
think that's like a very.
Like, I'm like, it's obviously a lot of work, but like,
Yeah.
All right.
respect that. Yeah.
All right, we're gonna get started.
Yeah.
Okay, we're gonna get started. We are so excited to welcome our guest speakers today on the Second Amendment, specifically after Bruen. And with us, we have Robert Leiter and George Moxery. I'm going to just read briefly about their biographies and introduce them to you. We have several people in the guest audience here, but then we also have some on the live stream, and we welcome all of you. So Robert Leiter is an assistant professor of law at the Antonin Scalia of Law, George Mason University. His scholarly interests are in criminal law and criminal procedure and constitutional law, especially concerning questions about the use of force and the rule of law. He has written on the law of self-defense, the constitutional allocation of military power, and gun control. Among other places, he has published in the Florida Law Review, the Indiana Law Journal, and the Wall Street Journal. Before joining Antonin Scalia Law School, Professor Leiter was at Arnold and Porter in Washington, D.C. He was previously with Mayor Bruen and was an Olin Searle Smith Fellow at the University of Pennsylvania Law School. He has clerked for Diane Sykes on the Seventh Circuit and Judge Clarence Thomas in the Supreme Court. Professor Leiter earned his BA at the George Washington University and a JD from Yale Law School, and a PhD in philosophy from Georgetown University. While at law, he served as an articles editor for the Yale Law Journal, and Professor Leiter now teaches criminal law and torts at George Mason. George Moxery. Before joining the faculty at the University of Wyoming College of Law as a professor, George was an associate professor at Southern Illinois University of Law. He entered academia after having practiced corporate and bankruptcy law at Cravath, Swaine & Moore in New York. Before that, he clerked for the Honorable Harris Harts on the 10th Circuit. Professor Moxery holds a JD from Fordham Law School, where he graduated first in his class and summa cum laude. He also served as notes and articles editor of the Fordham Law Review and was the recipient of Benjamin Finkel Prize in Excellence in Bankruptcy and Fordham Law Alumni Association Medal in Constitutional Law. Before going to law school, Professor Moxery earned his MBA from the University of Rochester Simon School of Business and ran a successful management consulting practice. His consulting clients ranged from the Office of the Mayor of the City of New York to J.P. Morgan Chase to the private bank of Pictet, thank you, and C in Geneva, Switzerland. Professor Moxery also holds a BE from Cooper Union Albert Nurkin School of Engineering. Professor Moxery is a co-author of Firearms Law and the Second Amendment, Regulation, Rights, and Policy, published in 2012, the first case book on its topic. He is also published in the George Washington Law Review, George Mason Law Review, Fordham Law Review, and other journals. His work has been cited by the Supreme Court of the United States. Please give a welcome to both of our guests.
Thank you, everyone, for having us. I always notice that whether I'm teaching a class or doing an event, all the students fill in the room from the back to the front. I've never seen them fill it in from left to right, though. So something, but don't worry, professors do the same thing. Like they'll sit all the way in the back and they'll fill it up. So I guess it's just human nature. So Professor Leiter and I will be talking about the future of the Second Amendment after New York State Rifle and Pistol Association versus Bruen. We'll be talking about different aspects of the case and hopefully our talks will complement each other. And then I think we'll have a little time for Q&A afterwards. So I'm going to start by giving you a brief background about District of Columbia versus Heller, which is of course important here, we're in the district. How Heller was treated by inferior courts, and in the process give you some background about the topic that's relevant, that'll be relevant when we talk about what actually was at issue in New York State Rifle and Pistol Association, which is public carry, public firearm carriage. Then I'll talk about what Bruen did, and what I think, kind of the main thing I think we can expect to see afterward, and then I think Professor Leiter will talk about some of the effects of Bruen and the purposes of the Second Amendment and how that plays in with Bruen. As many of you probably know, District of Columbia versus Heller in 2008, for the first time publicly and officially, I should say, declared that the Second Amendment protects an individual right to keep and bear arms. Heller was primarily about keeping arms in the home. It said that Dick Heller had a right to keep a revolver in his home. And it also said that DC residents had a right to keep a functioning firearm at home. So DC required that all firearms be kept disassembled and unusable at home. The Supreme Court said no, they have to be usable for self-defense in the home. Heller also strongly implied that the Second Amendment protects the bearing of arms outside the home. I'm going to do this. For the sake of time, I won't go into detail and why I think Heller said that, other than to say it spoke a lot about public carry, and it cited lots of cases from the 19th century that dealt with public carry. And we can talk in more detail about that in the Q&A if you like. But despite Heller's implications that the Second Amendment protects arm bearing outside the home, the judicial response to claims asserting a right to carry a firearm in public ranged from kind of mild confinement of government infringement to the right to a may-issue licensing regime. May-issue means that the issuing authorities have discretion in whether they issue you a license or not, and that discretion is basically unappealable. You typically have to show some kind of justifiable need, quote unquote, to carry a firearm in public. And usually to do that, you have to show some kind of urgent need for in fact, I'll read you a quote here about what Jersey's law looks like. Urgent necessity for self-protection, end quote, that's greater than just a desire to protect yourself or living in a dangerous place or even having received threats. And so some courts confine the right to carry in public to that kind of a system, and others outright defy decades of fundamental right jurisprudence. And I'll give you one example from a New Jersey case. That's why I mentioned the New Jersey statute, the Third Circuit case of Drake versus Filco. The court there applied what came to be called the two-part test, which was applied in Second Amendment cases. Under the two-part test, part one looks at how close the asserted activity, or I'm sorry, part one asks whether the asserted activity is covered by the Second Amendment. Right? And if it is, then in the second part, the court looks at how close that asserted activity is to the core of the Second Amendment, and the core generally was interpreted to having firearms in the home under Heller, and based on how close it was, it applied some level of heightened scrutiny, or means-end scrutiny. It was glaringly circular, but the courts applied it nonetheless. So in Drake, the court first held that public carriage fell outside the scope of the Second Amendment's protection because the justifiable need requirement in New Jersey was longstanding. And we can talk about that later if you want. Again, I won't go into detail there for the sake of time. But I do want to discuss the second part of the analysis, right? So the Drake majority performed an alternative analysis under what it termed intermediate scrutiny, but which was actually more deferential than rational basis review. Under the Third Circuit's version of intermediate scrutiny, the state bears the burden of showing that a given regulation does not, quote, burden more conduct than is reasonably necessary, end quote, in attempting to achieve its stated end. Most significantly, the court relied entirely, quoting again, the predictive judgment of New Jersey's legislators, end quote, that limiting the issuance of carry permits would enhance public safety. And that predictive judgment, to quote the dissent, was based on no evidence at all. And it was truly no evidence at all, nothing, like not a shred, not a scintilla, not a study, not even some claim about how it actually might lead to enhanced public safety. And the majority attempted to absolve the state from its burden by saying that when New Jersey passed the statute, Heller had not yet declared the Second Amendment to be an individual right, and that the legislature, therefore, could not have been expected to know that it should marshal evidence to support its law, the continued existence of its law. But a governmental entity can present, and a court can consider, evidence outside the legislative record when evaluating a law's constitutionality, as happened in another Third Circuit Second Amendment case that the Drake majority cited 23 times. So look, understand the import of this. This means that Brown versus Board of Ed doesn't apply to a jurisdiction that segregated schools before Brown versus Board of Ed was handed down. That's the implication of this case, of this reasoning, right? And there are many other cases like this, right? This is the kind of defiance that we regularly saw. It happened in New York State Rifle and Pistol Association 1, which is a case challenging another New York statute that we won't get into, but we can also talk about as well. And so the effect of all this, I offer, is that carry bans like existed in Jersey, like existed in New York, which was at issue in the case, that existed in DC and other places, tended to turn into criminals, peaceable citizens whom the state had no reason to have on its radar. But look, that's just me talking, right? The community was stunned when the Black Attorneys for Legal Aid Caucus, which was a group of over 100 Black legal aid lawyers, was joined by public defender offices in 9 counties in New York, including the Bronx and Brooklyn in New York City, okay, when they filed an amicus brief on behalf of the petitioners in Bruen. And these paragraphs from their summary of arguments say it far better than I can, and I'll just read you a couple of poignant lines here. Virtually all our clients whom New York prosecutes for exercising their Second Amendment rights are Black or Hispanic, and that is no accident. New York enacted its firearm licensing requirements to criminalize gun ownership by racial and ethnic minorities. And there's no question about that. It was passed in 1911. It's called the Sullivan Act. And the politicians who passed it openly stated that they wanted to disarm Italian, Jewish, and Black residents in New York City. And they kind of said it. At the time, that was just something that they felt comfortable saying, right? It was published in papers. So that's, easy to find the veracity of that if anyone doubts it. That remains the effect of its enforcement by prosecutors today. The consequences for our clients are brutal. New York police have stopped, questioned, and frisked our clients on the streets. They have invaded our clients' homes with guns drawn, terrifying them, their families, and their children. They have forcibly removed our clients from their homes and communities and abandoned them in dirty and violent jails and prisons for days, weeks, months, and years. They have deprived our clients of their jobs, children, livelihoods, and ability to live in this country. And they have branded our clients as criminals and violent felons for life. They have done all of this only because our clients exercised a constitutional right. So then came Bruen. In fact, this was an amicus brief filed in Bruen. The Bruen plaintiffs challenged New York City's May issue licensing system, and the main issue was whether such systems were valid. Under New York system, just to quote a couple of courts, New York courts that described how licensing worked in New York, an applicant, quote, must demonstrate a special need for self-protection distinguishable from that of the general community or persons engaged in the same profession. Another quote, another case, a generalized desire to carry a concealed weapon to protect one's person and property does not constitute proper cause. Obviously, neither is living in a high crime area or having been threatened, having your body or your safety threatened, neither of those are enough. And so what tended to happen in May issue jurisdictions is that people like security guards, famous people, retired police, their friends and their spouses, politicians, people like that got permits while the rest of us didn't. A great example is how in New York City, members of the rock band Aerosmith got their concealed carry licenses. Apparently, during the day, they went down to one police plaza in New York City, took care of all the licensing paperwork. That evening, limousines picked up the issuing officers and took them to Madison Square Garden for the Aerosmith concert. I bet you the tickets cost a lot more than anything I could ever afford. But in fairness, not all May issue jurisdictions were like this. Connecticut and Delaware, for example, issued on what was essentially a shall issue basis. Shall issue means that if you're not a criminal, not insane, you're mentally healthy, and you take a safety class, the state has to issue you a license to carry. So that left 6 states that required some kind of special needs, special showing. All of New Jersey, Hawaii, and Maryland, plus parts of California, New York, and Massachusetts. Notice that I said parts of California, New York, and Massachusetts. We'll come back to that shortly. There were other big questions, though, of which 2 were especially important. So the first was whether means-end scrutiny would apply per the 2-part test that I described earlier, that all but one circuit adopted. And second was what history matters and what didn't, because the first part of the test looks to history to determine whether an activity is covered by the Second Amendment. So then Bruen was handed down. It struck New York's May issue law. And the core rule, I think, that you get from Bruen is that discretion in who can exercise the Second Amendment right is not allowed. And the court had a great quote here. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. End quote. And I think that's exactly right. It applies in the First Amendment context, prior restraints are illegal, and so on. Right? Means-end scrutiny and the 2-part test, both are gone. Judicial interest balancing, like of the kind we saw in intermediate scrutiny, that could be abused the way I described as it was in the Drake case, is not allowed. And a corollary to that, explicitly stated in Bruen, is that the judiciary may not defer to legislative interest balancing either. Okay, an important point there. Relatedly, the burden of proof is on the government, which is normal for rights. That's how it should be in rights. That's not how scrutiny was applied in Second Amendment cases. And a comment here, I think this turned out the way it did because lower courts were so brutally abusing means-end scrutiny as we discussed, right? Had they applied heightened scrutiny in a meaningful way, I think the construct might have survived in the Second Amendment space, likely would have. Right, after all, the burden of proof is supposed to be on the government, even under tiered scrutiny, but again, it wasn't applied that way. So the court did away with the second part of the 2-part test and made explicit, as should be the case with constitutional rights, that the government bears the burden of proving the need for the existence of the regulation. In other words, this is in part the court asserting its authority. That's what was happening here. The core test from Bruen is, quote, text as informed by history. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And the government then has to justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearms or ownership and regulation. So, for example, and this is not as unusual as it might seem in the phrasing, let's say a Fourth Amendment litigant sues, asserting that the police officer stared at me for 20 minutes in the restaurant while I was eating in the restaurant. So the court would dismiss that complaint because staring at a person in a public place is neither a search nor a seizure. Right? So no Fourth Amendment claim and the case is gone. For Second Amendment cases, I think questions about whether the text is implicated are probably going to revolve around whether the arm in question is bearable and whether it's dangerous and unusual. And those are, to be protected, an arm has to be bearable. Dangerous and unusual arms are not protected by the Second Amendment. So what history matters most? The court broke it into 5 eras, medieval to early modern England, the American colonies and the early republic, antebellum America, Reconstruction, and the late 19th century and the early 20th century. In England, and the reason England is covered is somehow this whole legal discussion got into looking at old English statutes that regulated firearms carriage in various contexts, going all the way back to the 1300s. It's sort of this strange situation that organically developed. Here's what the court said. English practices that prevailed up to the period immediately before and after the framing of the Constitution and were acted upon or accepted in the colonies are relevant. So if it influenced the colonies and the founders' thinking, it's relevant. The colonial period is relevant to the extent that it informed the original understanding of the Second Amendment. Antebellum America, the closer to the adoption of the Second Amendment, the better, is the most important, right? That's the part that matters most. That's the part that really shows what the founders were thinking and what the public was thinking, what the public understanding was of the Second Amendment when it was adopted. The Reconstruction era is important, and the reason is that the 14th Amendment incorporated the Second Amendment against the states. So the interesting question is, what if the second foundings meeting, the second founding being the Reconstruction, the adoption of the Reconstruction Amendments, what if the second foundings meeting of the right to arms is different from that of the first founding? So that didn't matter in this case because the evidence of a quite robust Second Amendment right to arms during Reconstruction was just as strong as it was during the original founding period. Indeed, vis-a-vis personal self-defense, it's arguably much, much stronger. Congress explicitly spoke about the southern states taking away the freed slaves' right to keep and bear arms and protect themselves when it adopted the 14th Amendment and when it passed the Freedmen's Bureau Acts and the Civil Rights Act of 1866. So it's an open question. McDonald said, McDonald v. Chicago, which said that the Second Amendment applies to the states as well, said that the rights keep their 1791 meanings, but the majority in Bruen and Justice Barrett in a concurrence suggests that a different 1868 meaning might be relevant. So we'll see where that goes if it ever comes out. As for the late 19th and 20th centuries, they're much less relevant. They cannot provide insight into the meaning of the Second Amendment when it contradicts earlier evidence. Okay, so how is the history applied? It's applied by analogy. The court goes into things in some detail. One might ask why. I think it's an attempt to head off more defiance of the kind we talked about earlier. The court laid out basic rules for analogizing, which shouldn't have had to have laid out, were it not for the abuses of the two-part test that I mentioned earlier. These are things that any law student knows. So for example, quote, courts should not uphold every modern law that remotely resembles a historical analog because doing so risks endorsing outliers, end quote. Basic stuff, right? But you get a sense from the opinion that the Supreme Court is giving lower courts a lesson in interpreting the law here because they were so abusive in doing it before that. I think the court's analogizing, rules about analogizing can be referred to two metrics that are referred to, the how and the why. How means, quote, whether modern and historical regulations impose a comparable burden on the right to armed self-defense. A good example of this, which I know Professor Leiter disagrees with, is that, quote, the manner of public carry is subject to reasonable regulation. States could lawfully eliminate one kind of public carry, concealed carry, so long as they left open the option to carry openly. I think you might disagree with that last part a little bit, but I don't want to put words into his mouth. The why part means, quote, whether that burden is comparably justified. And I think this is the more interesting and important one, and its negative aspect will come into play from two angles. First, it prevents historic burdensome laws that were enacted for one purpose from being used as the basis to impose burdens for another purpose. So an attorney from Everytown for Gun Safety wrote the following. Militia and fire prevention laws impose substantial burdens on founding era gun owners, and he thinks that courts should uphold similar burdens, quote, regardless of the underlying motivation for the regulation. I think that's no longer true after Bruen. Second, and more importantly, much more importantly, it'll cause historical restrictions that were passed for later unconstitutional reasons to face a greater hurdle in the justification. So a great example is of the laws that were passed in the post-Civil War South that banned all but very expensive military revolvers. They were passed for the racist reason that the freedmen wouldn't have had them from service in the Confederate military, obviously. And they were so expensive that they couldn't afford them. Okay. So how will the test work? Professor Leiter will talk about that. I'd like to talk about, as far as the future goes, not about how the test will work or should work, but about the defiance that I think will continue to happen. There are a few lines in Bruen, all of which are basic rules of interpretation that I think can be hooks onto which hostile lower courts or even legislatures can base their opinions. I'll just give you one example. The Constitution can and must apply to circumstances beyond those the founders specifically anticipated, end quote. So that's a basic statement of what a Constitution has to do, right? But you can see how a court can use that to get to more or less any result that it wants. Okay, so of the 6 jurisdictions that had May issue laws, Maryland, Hawaii, and Massachusetts, maybe with a small exception in Boston, are so far following Bruen reasonably well. New York, California, and New Jersey are not, as I said. We'll discuss the New York law, the law that New York passed in response to Bruen, because it already has decisional law associated with it. California and New Jersey essentially copied that law. So New York's bill was passed after Governor Hochul sent a, quote, message of necessity to circumvent the state constitutional requirement that the legislature and the public have 3 days to deliberate over a proposed piece of legislation before it can be voted on. She and many legislatures said that it was too urgent not to pass immediately. I thought that was an odd claim given that the law wouldn't take effect for 2 months. Right? So here are the main features of the law that came out. And the important thing to note is that the list of sensitive locations is vast. It's gigantic. This is generally as categorized by Judge Sotheby in the Northern District of New York in the Antonio case. Here's a map of how officials in New York, and I thank Professor Leiter for this map, were issuing concealed carry licenses. And you can see that with the exception of New York City and Long Island, Rochester, and maybe Syracuse, most of the state was issuing on a shall issue basis or something close to shall issue. If you weren't a criminal, you were mentally healthy, etc., you would be issued the license. California was similar. Well, if the law stands with all of these locations being restricted, far fewer people in these states will be able to carry than before. So a bit of an irony there. So let's look at the features in some more detail. The column that says very bad are the ones I think are very bad. The rightmost column shows the ones that were stricken, and X means it was stricken in the Northern District, a check means it was upheld, and an arrow means that it was a change from a TRO to the preliminary injunction that came later. It's worth noting the Second Amendment stayed the enforcement of the preliminary injunction on Tuesday. Okay, so I'd like to talk about the stuff in the very bad column now. So the private property ban. So under the new law, bringing a gun into any building is a felony unless the owner posts a permission sign or grants express permission. But as the Antonio court pointed out, via this prohibition, New York is, quote, making a decision for private property owners that they're perfectly able to make for themselves, and in fact did make before the Concealed Carry Improvement Act was passed. And it also turns how these things work onto their head. It's difficult to say how carry in public is allowed if the default is that it's not allowed in a public accommodation, like a business. To make the provision worse, it exempts police officers, off-duty officers, and retired police. So if the provision were really about respecting the rights of property owners who felt uncomfortable having a gun on their property and to let them make an informed decision about having guns on their property, that all situations that didn't involve police being there for a legitimate reason, investigating a call or something like that, would require the property owner's permission. The good moral character requirement, if that just gets to dangerousness, it's just fine, right? But here's what the California AG said. Legal judgments of good moral character can include absence of hatred and racism, fiscal stability, or any arrest in the last 5 years, regardless of the disposition. So that does violence to the presumption of innocence, the First Amendment, and look, it punishes people for being poor or in bankruptcy, right? You had to get approval from family members to have a firearm in your home. Look, your exercise of a right can't depend on whether your roommates like it or not. 18 hours of firearm training, including 2 hours of live fire, probably okay, very likely okay. Boston, though, requires you to take off work, go take a police ferry to a police shooting range that's on an island in Boston Harbor and qualify with a 38 caliber double action revolver with a 4-inch barrel that the police provide to you, right? So Professor Nick Johnson at Fordham Law, who used to be a firearm instructor, said that many healthy people in their 20s can't handle the 15-pound or more trigger pull on a gun like that. He says that women, people with arthritis, elderly people, and so on won't be able to do it. He says it's not possible for them, though it would be entirely possible for them to use another firearm with a better trigger pull. He likened it to the, quote, superficial appeal and submerged discrimination of racist literacy tests that some states use to restrict voting access. The places of worship exception, no one should have to choose between exercising religious or Second Amendment rights, and clergy who live at their place of worship now can't have a firearm at all. Happily, that was stricken by Antoniuk and another case as well, so that's for now at least gone. Places or vehicles used for public transportation. In places like New York City, it's very hard not to use public transit. And contrary to what some might have us believe, the times that public transit is most dangerous at night is also when it's most deserted. Assemblies, you can't have, the statute bars firearm carriage at, quote, any gathering of individuals to collectively express their constitutional rights to protest or assemble. That can mean 2 people in their home talking politics. And Times Square. The statute says you can't carry in Times Square. So this is how everyone, including lifetime New Yorkers like myself, though I'm in Wyoming now, think of Times Square. That's how the police department defined Times Square. Okay? The justification was that a carriage there would make tourists uncomfortable. Well, constitutional rights don't give way to what tourists like or not, first of all. Most importantly, and look, they wouldn't see the guns anyway because they have to be concealed under New York law. Okay, so they wouldn't. So the reasoning just doesn't work. So at that, I think I'll stop there. I'll let Professor Leiter take over and add some thoughts, and I think we'll do questions at the end.
All right. How late are we gone? I want to leave a little time for questions.
So we have, maybe we can leave 5 minutes for questions at the
Okay.
end. So 5 before the hour
Are we going to one or are we going after one?
until 1.
Okay. So thank you, George. All right, I want to pick up, I guess, that's what Bruen did. I'm going to talk for a minute about what Bruen did, and then I'm going to go to where we're headed. So Bruen held that the Second Amendment secures a right to bear arms in public for purposes of individual self-defense. In that, it followed a long series of decisions on the right to bear arms that came out of the state courts. This doesn't come out of nowhere. This had been the predominant American rule for the last 200 years. Bruen did not hold, and this is important, Bruen did not hold that there is a right to carry a concealed weapon, and it did not hold that the right cannot be regulated. So the right is to carry arms in some form outside the home for private self-defense. It is not to have any particular kind of licensing scheme or to carry it in any particular manner. And so the irony of this, Professor Roxbury went through the various states. The irony of this is Delaware, if it wants to go back to enforcing its need requirement, can probably do so because Delaware restricts the carrying of concealed weapons, but allows individuals to bear arms openly without restriction. So it is, it is still the case that if states want to have a kind of may issue licensing system, they can do it, provided they leave some alternative means of exercising the right available. What we are seeing is that states, for various political reasons, are moving to shall issue licensing, including New York. But New York could have very simply said, look, you have a right to carry a gun openly, and we'll keep the Sullivan law in place for concealed weapons. Could have done that if it wanted to, did not do that. One of the ironies coming out of this situation, or coming out of Bruen, is that the situation on the ground in the may issue states is far worse for many gun owners than it was before. So as you see from these maps, at least geographically, if not by population, of the 6 states that were enforcing a need requirement, 3 issued licenses at the local level under local criteria, and most of these states geographically issued them under what was effectively shall issue criteria. And the irony of these states was always that it was very difficult to get a license, but once you got a license, you had a lot of freedom to carry a gun in public with the license. And so there are a lot of people in New York who had unrestricted licenses, and for whom the restrictions on the license were don't carry a gun into a school or courthouse or legislative building, but there wasn't much past there. Now, as you can see, the restrictions are extensive. So gun owners in a lot of these states are actually far worse off than they were before Bruen came down. And of course, this is going to spawn a lot of litigation. And so the thing that Bruen leaves open is how states can regulate the right. So again, Bruen does not state that the right is beyond regulation. All rights are subject to regulation. The First Amendment, which says Congress shall pass no law abridging the freedom of speech. It just raises the question, what is the freedom of speech? And the court has held, for example, that reasonable time, place, and manner restrictions do not abridge the freedom of speech. And so we face an analogous question on the Second Amendment side. How far does the police power extend? And the police power is the traditional prerogative of state governments to regulate rights in the public interest. So, police power regulates property rights. These are things like trespass rules and how property is conveyed and all that. Generally, the police power does a few things. It makes the rights regular. It prescribes how you can exercise them. It also is a power to prevent people from abusing their rights to infringe the rights of others. So that's you cannot use your property in a way that infringes the right of others. So you may be able to play music on your iPhone at a reasonable level, but if you connect the iPhone to a large external speaker and blast it in a way that creates a nuisance for other people, you can't do that. So the police power is the idea in part that the government can regulate the exercise of rights so that you don't infringe the rights of others. And what's at issue right now is we need the theory of the police power for the Second Amendment. And the court doesn't exactly frame it that way in Bruen, but that is in fact what it's doing. And so the major issues coming out of Bruen are what types of regulations are permissible and aren't permissible. And I think there are 3 or 4 sets of issues that are really live right now. First are questions about the right to keep arms. Does it extend to so-called assault weapons and large capacity magazines? Second is, how far does the right to carry arms extend? Can New York do what it did here as an exercise of the police power? It's not a total ban on public carry because you can still carry on the streets, but you add all this up and you can basically go nowhere with your weapon. So the second is, how far can the sensitive place doctrine extend? And the third, the one thing that New York did, which was immensely creative to limit the scope of Bruen, was to kind of co-opt private property by saying the default rule on all private property is you cannot bring a gun back with felony level penalties. And if a private property owner wants to change that, he can, but you have to opt out. So what that does, it's virtually impossible to carry a gun in New York right now. Even if you had it in your car, you couldn't stop for gas, you couldn't go to the bathroom. I mean, so basically, you add up all the restrictions, and New York actually has a more restrictive law today than it did when Bruen was decided. So, question is, where are we going today? And the problem with Bruen is Bruen right now says, well, you can pass laws, we're going to adopt a text, history, and tradition test. Figure out whether the law is within the text, whether it regulates something within the text. If it doesn't, it's okay. If it is within the text of the right to keep and bear arms, you move to a second step where you say, is it consistent with this nation's historical tradition of regulating firearms? Problem with that is that for the first 100 years or so, there were actually very few laws regulating guns. There were some laws against people who were outside the political community and viewed as dangerous. People like the Loyalists during the Revolutionary War, slaves and free blacks. They could not possess guns or had to get a license or swear a loyalty oath, depending on the case. There was a common law prohibition against going armed to the terror of the people, which there's a dispute about exactly what that covered. Some people think it covered any public weapon carrying. I don't think it went that far. I think it only covered that carrying that was done in a way that tended to put others in fear that there was going to be either personal harm or a breach of the peace. And then early in our history, there were a bunch of Southern laws against the carrying of concealed weapons, and that kind of regulation actually spread throughout the country. But there weren't the kinds of, there were not restrictions on the kinds of arms that you could own. There were some restrictions like how much gunpowder you could have so that your house wouldn't be a fire risk to the entire community when you have wood structures. But there weren't, if you wanted to own a cannon at the framing, you could do it. They're just, the amount of historical laws you can draw from is very, very thin. And so the question is, how are courts going to do this? And I think there are two ways to do it. One way that the courts are doing now, which doesn't make a ton of sense, and a way that I think might make more sense, a way that's a little bit looser with the analogies, but might make more sense. So right now, what courts are doing is they are quite literally trying to find founding era analogs of laws and saying, are these laws close enough? And so you have a somewhat ridiculous exercise that if you want to justify a ban on felons possessing firearms, they're going back to the framing and saying, okay, well, you can ban guns from Native Americans and slaves and loyalists on the theory that, and Catholics, on the theory that they might pose a danger to others. So we're going to, say, well, okay, groups today that might pose a danger, you can ban them from having guns. So you have somebody a somewhat untoward application of these old racist gun bans as justifying modern laws. But that's not going to get you very far. I mean, there was no prohibition on felons possessing firearms, and the modern definition of a felony, which is any crime punishable by more than 1 year, is far broader than what the definition of a felony is in common law. So, I mean, right now what you have courts doing, so this is what you have courts doing, and you have some pretty quirky judgments in the district court. So you have courts, you had a district court say the ban on possessing a firearm with a defaced serial number is unconstitutional because there were no serial numbers at the framing, and defacing a serial number was not unlawful. And I just think this is totally ridiculous. The federal prohibition of possessing a firearm with a defaced serial number doesn't prohibit any person from possessing or carrying any kind of weapon for any purpose. It is the quintessential police power regulation in that it prohibits altering a firearm or possessing an altered firearm in a way that's designed for criminal application with no lawful purpose whatsoever. So, I don't think this should even really fall within as a restriction on the right to bear arms. But anyway, I think there's a second approach, and the second approach is looking more towards our traditional regulation to say, okay, what kinds of things could the police power do, and how can we apply that today even if we have novel circumstances, like you have a prohibition on carrying weapons aboard commercial aircraft. I don't think what you do is go back and say, well, was there a prohibition on firearms in boats or on trains? I think you go back and say, okay, there were specific incidents where the government could prohibit wholesale the carrying of weapons in narrowly defined locations. Is this, are commercial aircraft that kind of place? Whether it's directly analogous or not. And I think that's what Bruen is trying to say. That is not what the lower courts are doing at the moment. But to do this, you're going to end up with some sort of means-end scrutiny. And I think this is the thing that is kind of underneath Bruen that remains very much unsettled. Heller says the right to bear arms is an individual right. Bruen says it extends in public. What you do not have at this moment, however, is a consensus, even among the conservative justices in the majority, about what the Second Amendment is trying to accomplish. So there are three traditional theories of what the Second Amendment is trying to do. The first is that it enables individual self-defense against crime. The second is that it provides for collective self-defense. That what it does is it decentralizes the military power and it makes the military power retained within the general citizenry. And what the goal is that by securing a general right to bear arms, you prevent the government from creating specialized armed factions of individuals and then investing those armed factions with the monopoly of legitimate force. That this is the fear that the framers had coming out of Britain, that they didn't want regular soldiers being invested with the complete monopoly of force in society. And so by guaranteeing a general right to bear arms to the community, there is no specialized armed faction within society that maintains all the force. And the third, the one that prevailed, the collective rights view that prevailed in the federal courts from about 1930 until Heller, was that it guaranteed the existence of state military forces, that basically allowed states to create their own armed factions with no federal oversight. I think this was, and I think the third one I think is just clearly wrong, completely antithetical to what the Second Amendment was designed to accomplish. I think the Second Amendment was principally designed to accomplish preventing armed factions from developing in society with the monopoly of force. But at any rate, if you look at the 19th century cases debate whether it just provides for the right to bear arms, just provides for collective self-defense, or whether it provides for both collective self-defense and individual self-defense. No one takes this third view. This third view doesn't develop until the 20th century. The issue today is that people don't understand, don't have a theory of the military-related value for the Second Amendment. So Heller talks about the Second Amendment in terms of individual self-defense. And the question today is whether the Second Amendment, the purpose of the Second Amendment is only individual self-defense against crime, or whether it is both individual self-defense and military-related applications. And the answer to that will then help, the answer to that is necessary for figuring out how to specify the right. If you want to ask whether a ban on assault weapons is constitutional or not, if you think all you're doing is enabling self-defense against crime, it's easy to say, well, we're just banning a narrow class of weapons that are dangerous to the community, but we're leaving a vast array of weapons available for individual self-defense. If you think, however, that the Second Amendment is designed to promote both individual self-defense and military-related applications, then a ban on assault weapons is very problematic because those weapons get to the core of the military-related function that the Second Amendment is trying to protect. And so I think for courts to do this, they're going to eventually have to come up with a coherent theory of why the Second Amendment protects the right to bear arms. And this is the most important unstated thing that currently is running through these cases. And until you have a theory of that, you can't do constitutional construction with novel issues, because the construction that you're going to do, the area where let me end with this. The area where the police power ends is when you're regulating the right in a way that undermines the core objectives of the right. That is the one thing that you cannot do when you exercise the police power. So let me stop there, and I'm a little over where I wanted to be, but let's take questions from here.
Let's, well, thank you, both of you. I think.
Here's a
Yeah,
couple
please,
minutes.
couple questions, yeah.
I had a question. For the second theory that you talked about here, the idea of being able to not limit military power to the government, do you see an extension of the Second Amendment into cyberspace? How does the right to bear arms consider the right to bear arms in the virtual world?
I haven't thought about that. You're the tech guy. I mean, I don't know. I think it's more metaphorical at that point, but maybe, maybe not. I mean, you can do things with computer viruses like actually harm people.
What are you thinking? Did you have something in mind?
Yeah, I mean, I guess I'm just thinking in terms of like even carrying a signal blocker in a public space to where I'm blocking the ability of others to mine my data, is that something that could be protected under the Second Amendment? With the idea of, I mean, the military is moving away from just assault rifles as being their weapons. Now there's a lot of cyber weaponry. What is the application for an individual being able to obtain or?
Yeah, so it gets to the tyranny control aspect of the Second Amendment, which is kind of implicit in 1 and 2. In here, I might make that a third category here. So if somehow the federal government is using technology to tyrannize the population, and there's some way that technology that the population can use to protect itself against the federal government, I think that's where that argument, or that's where the question would come into play, and then we can kind of debate, how broadly the Second Amendment goes, what it protects. Is it bearable? Is it an arm? Those kinds of things. But that's a fascinating question, actually. I never thought of it that way. But, one thing that all 10 justices who decided Heller and McDonald agreed on was that the Second Amendment had a tyranny control purpose, right? So I think probably that's where it would come into play somehow.
By the way, we do not have another class afterwards, so if anyone wants to keep asking your questions, you can. We don't have a hard stop.
Yeah, I have a few minutes.
Yeah. Any other questions?
Go ahead, sir.
Kind of had a question. I missed some of this, so maybe I missed an important part of it. But the existence of state military forces, is there a realistic, let's say, in our federal system, let's say if we have a federal government that's acting tyrannically in a hypothetical scenario, do we actually foresee state military forces being able to have some type of resistance against the federal, I guess, federal military? It's never termed in that sense. But how far do we actually foresee state military forces being able to withstand against the United States Army, or am I misinterpreting?
No, I think this is kind of the collective rights view of the Second Amendment that I don't accept, but I think this is what a lot of collective rights scholars think, is that the tyranny resisting purpose of the Second Amendment was to have state governments arm their own military forces to resist the federal government. And I think this is a misunderstanding of what the Second Amendment was trying to do. So the kind of post-20th century view of the Second Amendment is that it's based on federalism. You have the federal army and the state militia. This is not what the framers understood. What the framers were getting at when they were separating the armies from the militia was separating out what today we would call the regular forces from the non-professional forces. There was an idea at the framing that the regular forces were particularly dangerous, that having a professional society of armed men who live under military law, who do not share the same freedoms that they are protecting, is dangerous is dangerous in a democracy that is committed to both civil liberty and the rule of law. That, for example, at the framing, you had what was called the Newburgh conspiracy, where the soldiers were ready to mutiny on Congress because they wanted their pay, and they didn't care who cut the check. And General Washington gave a very famous speech where he put down the mutiny. But this was the kind of fear that by having a separate society of professional armed men that you would undermine, who lived under military law, whose, the virtues were obedience and training to kill others. Like, this is what a professional soldier does. That this was not something that was compatible with a Republican government. And so it is not really federal forces versus state forces. What they were the dichotomy that they were doing were between professional forces, those whose full-time employment was learning to kill other human beings, and non-professional forces, individuals who were citizens, who took on military obligations as needed, but then when it wasn't needed, were back into civilian life and lived under civilian law and had civilian rights. And so today, I don't think if you were asking, could states rise up against the federal government? Probably not, but that's not what the framers wanted. What the framers wanted was the ability to check the professional forces if the regular army decided that it was going to try a coup. And I think the modern militia, I have a paper coming out on this, but I think the modern militia today is not the National Guard. The modern armies is not the U.S. Army. The armies are split between different bureaucratic departments. You have the Army, the Air Force, the Space Force now, arguably the Marine Corps. You can debate whether they're properly within the armies or the Navy. But the modern armies are not within a single bureaucratic department. I think the same is true for the modern militia. I think the modern militia is split between things like the National Guard, the Army Reserve, the people who are registered with the Selective Service System. And so the question you would have to ask today is, if the professional army tried to overthrow the government, could the citizenry check that? And maybe they could. I think what the framers had in mind was something like Donald Trump says the election, it wasn't legitimate, and I'm staying in power on January 21st or January 20th. And General Milley says, you know what, President Trump, you're right, and the army is with you. If something like that happened, could the citizenry check that from happening? You could debate that. I doubt something like that happened. The professional army would move as a whole against the citizenry. I think things would be a lot more chaotic. The other thing that's forgotten about this, and then I'll be quiet, by decentralizing the military power, one of the things the framers was trying to do was limit the size of the standing army. So if you have a body of citizens who are trained to arms and can be brought into service quickly, then you don't need to hire as many regular soldiers. And the smaller standing army you have, the fewer tensions you have between the military and democratic society. Because as you need people for war, you can just bring them in quickly. And today, if you learn to shoot on an AR-15, it's not exactly an M16 rifle, but it's very, very close. It's close enough that somebody who's proficient could go into a military environment with an M16 with very little additional training. And so I think what the framers were doing with the Second Amendment was allowing the citizenry in part to train themselves so that the country wouldn't need as many standing forces, so you don't have to deal with the civil military tensions that are created by having large bodies of professional troops who live under military law.
Yeah, I think that's all right. I would just add to that not to underestimate the ability of a population to resist, right, and to overthrow a government that's tyrannical. I mean, witness our nation, right, and how it came about, right? The theory that a large, overbearing national power will always win actually is a historically defective notion. It just doesn't always work out that way. Witness the Arab Spring, for example, of some years ago. So an armed population is able to resist in all of the ways that Robert said and others say.
So you talked about how after Bruen we have the text history tradition test. And with a court that is mainly committed to originalist thinking, textualist thinking, kind of with that novel idea of an automatic rifle, right? You're not going to find any laws in the first 100 years of our history or text or tradition that match those laws, right? And so does it conflict them kind of going with, I guess with their core principles to kind of even think about a purposivist approach?
I don't want to call this a purposivist approach. I think when you do construction, once you're within the text, then purpose matters, but purpose doesn't override text, which is the traditional purposivist approach. look, I think the fundamental problem with Bruen is that the examples they give, like felon in possession, they improve in dicta the shall issue licensing. None of these have historical analogs. And so the method that they announce is not consistent with the examples that they give. And so courts are going to be a little bit adrift with this.
Yeah, here's how I kind of think of this. If there's a good amount of law, right, statutory law and decisional law, interpreting that statute in the early 19th century, let's say, as it was for concealed carry, it's easy, right, as Professor Leiter said. What happens, though, if all you have is statutory law that was never challenged? Harder to say, right? It's much harder, but look, we've got some history, maybe we can do something with it. But what if you have neither statutory law nor obviously decisional law telling us whether that statutory law is good or not? And a great example, taking the AR-15 or an M16, whatever, or an assault weapon ban, so-called ban on so-called assault weapons. What do you do with the fact that the Girandoni rifle could shoot 22 rounds in 30 seconds, and each round could take an elk? Far more powerful than an AR-15, right? If you're shot once by that, you're dead, right? With an AR-15, people live all the time. The military, our soldiers complain that the M16 round is too weak, right? But what do? Right? This weapon existed. There was no regulation on it, and no decisional law, no common law telling us whether the regulation is okay or not, because it never existed in the first place. I think that's where the rule is going to have the most trouble, where you've got neither of those types of law.
And that's when you're going to need a theory of police power. And to have a theory of the police power, you need to understand what the core of the right is, because that marks the outer limits of the police power. And so a core of the right that's around individual self-defense against crime isn't going to look the same as a core of the right that also recognizes some military related application.
Thank you.
Thank you very much, everyone. We really appreciate your having us here.
Thank you.
Yeah, we just want to thank again our speakers, and just an announcement that this is the last event for this semester for us. Everyone go and get your finals already. I know you're doing outlining and it's a busy time. So this will be the last event for this semester, and we'll start up again next semester in January. Thank you.
Thank you, everyone. For the lecture, what I do for the lecture, just we went over time and it was really interesting. Yeah, it's always good.